One, as far as the pistol whip, um, I don't think there's any disagreement that him getting pistol whipped did not cause his liver failure. What
All right, I want to say good morning, everyone, and let's go ahead and set forth our appearances on the record. We'll start first with the plaintiff, then we'll move to the defense.
Your Honor, Will Kemp, Teddy Parker, and Eric Pepperman, the plaintiffs, and Brianna Switzler.
Good morning, Your Honor. Joel Odou and Matthew Kaufmann should be on Zoom. TV's on for the real water defendants.
Good morning, Eric Freeman and Eric Storm for real water as well.
All right, does that cover all appearances?
Yes, sir.
Okay, once again, good morning. I guess this is time set for pre-trial limiting motions. Just as a side note, I think all the jury questionnaires have been signed. And we took care of, I think, the final one on last week, I think on Thursday or Friday.
That's our understanding, Your Honor, yeah.
Okay, and hopefully you've gotten those.
We did. We got a bunch on Friday, Your Honor. Thank you.
Okay. So where do we go from here?
Your Honor, I was gonna ask, I tried to reach out to Joel over the weekend and
We
listen,
weren't able to.
we weren't able to get together, but my suggestion is I'm fine. I think the plaintiffs are all fine with allowing the court to make decisions on the briefs for motions that were already heard and approved or I guess granted or denied the last time. I don't know if Joel is willing to do so. I only have 2 days. Your Honor has given us 3 days. I only have 2 because of commitments on Wednesday. So I'd like to save as much time as possible. But the plaintiffs are fine with that.
Your Honor, Joel Odou on behalf of the real water defendants. I think that the quickest way to handle, we didn't get a chance to get together, first of all. Apologize for that.
We still have more time for that.
I think we will get through them. I think that we're prepared to just go in the order they appear on the court's calendar and certainly can highlight for the court any new or additional arguments or just say, hey, Your Honor, this is the same as before. That's probably the most efficient way to do it. But I am willing to proceed in any fashion. In addition, the parties are working behind the scenes to try and resolve some issues as well. Unfortunately, there's just a lot going on and
Would be nice if they could resolve this case, right?
we would love that. But that doesn't look like that's gonna happen, unfortunately. So it's probably best to just call them in the order they appear on the court's docket. We can certainly I will tell the plaintiffs as it's called if, there's any additional things that we want to add, and then they could add first if it's their motion, or I'll add first if it's one of ours. But I think a lot of these are going to.
It does help me from trying to figure out what's been done and not been done, but by making sure if it's how I ruled prior, and I can rule in open court unless there's something drastically changed factually.
There are a few changes, and I think that's a great suggestion, Your Honor, for the ones that there's not. I think it's, I think some of the motions are that the court has previously ruled on the legal issue. We still will want to get clarification as to what's in, what's out. And in particular, the court made some rulings in the Gallagher case about prior incidents, prior things that happened.
Was that my 6-point test that I created?
Probably.
When I read all the cases.
All the cases, Your Honor, every one of the actual customer complaints. So that hearing by itself took over a day. But we also have.
But I want to make sure, and I don't want to cut anybody off, but I went back and read all the cases.
You did.
And I came up with, I said, I thought about it and I said to myself, okay, in reading the cases, can I formulate some sort of test that combines all the cases and the thoughts? For example, I forget the name of the ladder case.
Exactly.
And when they came down the ladder, there was no evidence that they even hit the lever.
That's right.
So the Supreme Court said, okay, that can come in. To me, that was a really big issue. What case was that again?
That was Krause, Your Honor.
Krause, yeah.
Yeah, I think that's a good example of something that will go very quick. I think the question that we would have from real water standpoint is which prior acts, does that include, which prior complaints does that include from a factual standpoint? Because not all of those that were offered in the Gallagher case may be even offered here.
I understand.
The only other housekeeping or scheduling issue I have, Your Honor, because I have a board hearing today at 1. If we could go a little longer and take our.
We'll accommodate you, Mr. Park. Don't worry, we have
Maybe
time.
1:45, come back at 1:45.
Whatever.
But we'll figure it out. We'll figure it out. Don't worry about that. You got to go to your board meeting.
That's all I have.
So, yeah, Your Honor, that sounds great.
Okay,
We would love nothing more than to finish tomorrow at the worst.
all right. Yeah, from an appellate perspective, I was thinking about what our Supreme Court would do with my 6-step analysis.
Well, I'll tell you, Your Honor, in the other 2 cases we tried, customer complaints came in all of those cases.
Yeah, I understand.
Not all of them, but yeah.
But the only reason I say that, I actually gave a reason.
You did.
Yeah, I mean, it was based upon prior case law, and their analysis and so on and so on. And I do think the Kraus case really opens it up. That to me, that was, I guess Shoshone and all the other cases, but Kraus, when you read it in detail, to me, that really opened the door as far as prior events. And, all right, so we're going to start out with plaintiff's motion limiting number 1.
Yes, Your Honor, is Mr. Kaufman on Zoom? Can he hear us? I just don't see him.
I'm here, Joel.
He's there.
All right, awesome. We're ready to proceed. Go ahead.
Motion sometime.
I think he said MIL 1. That was the order there on the docket. I don't have any preference at all.
I mean, I'll summarize number 1 for you. I mean, it's a motion limiting to exclude issues of alcohol usage based upon the fact that it appears it doesn't meet the assistance requirement under HOMA. How's that?
Yes, Your Honor. Your Honor, this is pertaining to Mr. Henry's case.
Right.
Henry is the liver transplant person. And this is the rare case where we actually have a medical record attributed to real water. That's because it came late after the investigation started. But USC, they looked at the tissue slides and they said, quote, findings are more likely related to acute liver injury related to real water. So you would think that would be the end of it, right? But no. So what has happened here is they have an expert, Dr. Robin from San Diego, a pathologist, and he intends to opine that, it wasn't really real water, it was alcohol. So the problem with that is Mr. Henry was 24 years old at the time of his liver transplant. And we know from the science that it takes 10 years of moderate to heavy alcohol use to cause cirrhosis that would justify a transplant. 10 to 15 years of moderate to heavy alcohol use. And we've cited the science. We've cited the testimony of their hepatologist, Dr. Lynn, who says exactly the same thing. There are other hepatologists, Dr. Pordad, and this is on page 11 and page 12, and we cited again the reply. So 2 of their experts say, yeah, this is the science. And then Dr. Robin, the one who wants to propound the alcohol theory, he admitted that the science was 10 to 15 years. The published literature is all 10 to 15 years. So I asked him at his deposition whether he could come up with any literature to the contrary. And he came up with one article that actually said 10 to 15 years, which was Robin, no relation, but Robin on pathology. So all the literature, 10 to 15 years. In their opposition, after we filed the motion, I would have thought that they would have come up with at least one paper from someplace, not one single scientific article, not even a non-peer-reviewed scientific article saying anything less than 10 or 15 years. So instead, they want Dr. Robin to speculate based upon a treatise that says maybe if you have a genetic defect, you can have an accelerated time frame to develop cirrhosis from alcohol exposure. So first of all, that's a maybe theory. That's not science. That's speculation. And second of all, they speculate that there's a genetic defect that Mr. Henry had that must have, accelerated this. Well, Dr. Robin admitted in his deposition that there's no proof one way or the other that he has this genetic defect. He hasn't been subject to any genetic testing. And Dr. Robin also said that as he sits here today, he can't say one way or the other whether or not the genetics caused the acceleration. So, based on that, we have number one, no science, and number two, this genetic speculation. So for either reason, this alcohol theory should be out of the case, Your Honor. And so that's what we would ask.
All right, thank you, sir. And we'll hear from the opposition.
Thank you, Your Honor. Joel Odou on behalf of the real water defendants. First of all, there's two issues of material fact here that are in dispute. One of the issues of material fact in dispute is the claim as to when Mr. Henry started drinking. That is an issue of material fact that's going to be up to the jury to decide. The plaintiffs would like you to believe that all of the defense rests upon him only drinking for 2 years, and that is completely inaccurate from a factual standpoint, also based on the medical testimony of the defense experts. Mr. Henry had a long history of drinking. He also had a large weight loss. He was obese as a minor. He lost weight. The doctors have said that, look, if you lose a lot of weight and you abuse alcohol, there is a higher chance that you will develop cirrhosis of the liver. The plaintiffs want to argue that the cirrhosis developed within 2 years. That is an argument. That is not a statement of any medical expert on behalf of plaintiffs. Plaintiffs want to proffer that testimony. They need a doctor to say that that is a claim in this case. Certainly, if Dr. Hudson said, yeah, this cirrhosis developed within 2 years, he could have said that. He didn't. Dr. Robin has come up with a long list of reasons why his medical opinion is what it is. During Mr. Henry's interview at Mountain View Hospital, the social worker developed a reliable patient medical history. Those are admissions that he had ethanol and drug abuse. These are reliable admissions. He was oriented 3 times 3, time, place, all of that. Plaintiffs would like to argue to the jury that it was encephalopathy and therefore these statements are inaccurate. That's an argument, Your Honor, that goes to weight, not admissibility. The statements are what they are. Mr. Henry stated, according to his medical records, he consumed 1/2 of a fifth of alcohol and up to 5 to 6 beers a day for 2 years. That's the 2 years that they have focused in on, but they're not looking at his entire record. In addition, Dr. Robbins cited animal studies of ethanol metabolism and how it generates different effects on a liver. He talked about the histopathology of the liver that was removed from Mr. Henry that showed bridging fibrosis, cirrhosis, all the features that were noted by Dr. Datnow, plaintiff's expert. Again, going to weight. Dr. Robbins says, look, this liver is a liver that was damaged by alcohol abuse, not by a toxin. He says that although Mr. Henry is 24 years young, and that's young for cirrhosis, the metabolic issues and drug abuse that he developed in his childhood could lead to cirrhosis and did lead to cirrhosis. He puts this all in his report, and to say that, this is speculation, well, they haven't brought a motion under Hallmark to exclude the opinions of Dr. Robin. They brought a motion to exclude Dr. Alsina. We'll talk about that later. Instead, they brought a motion to exclude first they brought a motion making an argument that we're not making, saying that there's this much that he developed the alcohol within 2 years. We're saying it's up to the jury to decide when he started drinking. There's evidence that he drank longer than 2 years. We're also saying the jury's got to decide if his alcohol consumption for whatever period caused his cirrhosis of the liver. Dr. Datnow even acknowledges the changes that Mr. Henry had in his liver, and that all of these things that he had in his liver are not specific to a toxic liver injury caused by something like hydrazine. So even their own expert concedes that there are material issues of fact here. This is an issue that goes to the weight, not to the admissibility. Now, as far as the one-line throwaway in the pathology report from USC, that's the hospital parroting back what Mr. Henry said to them. Just like we want to be able to rely upon Mr. Henry admitting his alcohol abuse, they want to be able to rely upon Mr. Henry telling the hospital in March of 2021, oh no, this was caused by real water. Again, that creates a material issue of fact. We can't take one without the other. The jury's got to decide between Mr. Henry's statements what caused his liver failure. Finally, the doctor testifies to a reasonable degree of medical probability that Mr. Henry's end-stage liver disease was the result of excessive alcohol ingestion. He doesn't say within 2 years. He says in gestation. So it's up to the jury to decide if their defense claiming that he didn't start drinking until he was 22 years old is a credible one. Your Honor, we took the deposition of Dr. Hudson. Dr. Hudson opined that, oh, he's going to believe Mr. Henry when he tells him that he only started drinking at age 22. That's fine. Dr. Hudson can say that, but we can cross-examine Dr. Hudson about that belief, and the jury can decide if that's truthful. Dr. Hudson also said Mr. Henry didn't have any evidence that you would see in an alcoholic, completely not seeing that. Unfortunately, Mr. Henry was admitted for alcohol poisoning. He'd been pistol whipped. He was in a fight at a bar. These are all in Mr. Henry's records. They all go to weight. They don't go to this theory that alcohol developed in 2 years. That's something the plaintiff's attorneys have come up with, not the experts. Your Honor, this is absolutely a material issue of fact. It's in dispute. Finally, also in commenting on that USC record, since I'm a USC alumni and they didn't do so well this weekend.
They shouldn't go to the Big Ten. That's the problem. Nebraska found that out, right? That's
Well,
it's taken them 10 years, 15 years to look decent in the big. But anyway, that's just a side note.
That's right. We got to get some offensive linemen trained. Your Honor, here's the point. It wasn't a medical board meeting. They didn't roundtable this. It wasn't a finding of USC. It was a note in a medical record, no different than the notes that we want to rely upon when Mr. Henry says, hey, I was pistol whipped, or when Mr. Henry reports he's been abusing alcohol and how much he's been drinking. This is post liver transplant. All of that goes to the weight of the evidence. Ultimately, it's a disputed issue of material fact. And the plaintiffs can't rely upon this one statement to say, aha, this is the cause. They can rely on that statement that it was made, that it was in the medical records, but it's up to the jury to decide if that one statement outweighs the pathology of his liver and all the testimony of Dr. Robin as to what he found in looking at the pathology slides. And as far as Dr. Lynn goes, it's the same thing, Your Honor. You're showing Dr. Lynn one record out of context. He even noted it was out of context. And it was what Mr. Henry reported, not what they found. It's not a medical finding to a reasonable degree of medical probability by the University of Southern California that Mr. Henry was or had a liver transplant as a result of real water. That is a big stretch. And so for all those reasons, Your Honor, this motion should be denied.
Your Honor, first of all, we are conceding for purposes of the motion that he was a heavy to moderate drinker for 2 to 3 years. We're conceding that. Okay, that's the evidence that Mr. Odou is saying there's an issue of fact. I'm not arguing that. I'm assuming all facts in his favor. Okay. But the science, which you didn't hear one single word about science or literature. The science is unequivocal that you have to drink for more than 10 to 15 years, heavy to moderate usage to get cirrhosis. 10 to 15 years, again, he was 24 at the time of his transplant. So they're saying that they're going to be able to prove to this jury that he started drinking at 14 or earlier. That's what he said.
9 to 14.
Yeah, 9 to 14. So that's the issue of fact. So he keeps saying there's a material issue of fact. As we point out in the motion, the only 2 witnesses that they've deposed is Mr. Henry and his mother. Neither one of whom say he started drinking when he was 14. They don't have one single medical record that says that. And I asked Mr. Alcina that, and Dr. Alcina, excuse me, he's their hepatologist again. He conceded that there was no medical record whatsoever that supported the proposition that he drank before he was 21. None. There was none. And today, Mr. Odou keeps saying issue of fact, issue of fact. He's got to identify an issue of fact to show that it's past the 10 to 15 year period. He doesn't have one single witness, one single medical document, nothing. He just wants to throw mud on the wall and have Dr. Robbins say, oh, well, maybe there was a genetic thing. I don't know. It looks like alcohol to me. Maybe the client, maybe he started drinking at 10 or when he was 14. And I asked him that question. I asked Dr. Robbins, I said, do you have any evidence whatsoever that he started drinking at 14 earlier? None, not one single. He said, well, maybe that happened. That could have happened. That is not evidence that creates a material issue fact, Your Honor. That's sheer speculation. So given that they haven't refuted the primary point, which is that it takes, under all the science, and their doctors, Dr. Lynn, Dr. Poordad, their doctors, their two hepatologists say it takes 10 or 15 years to develop the cirrhosis. So there's no dispute what the science is, and there's no evidence he started drinking at 14 or earlier. So to allow them to present this theory is just, like I said already, throwing mud against the wall. Let me check my notes, Your Honor. Oh, and Dr. Robin, you know, this speculation, this is a direct quote from him. They say, oh, there's some evidence that there's a genetic mutation. So I asked him, question, okay, until more information, you can't say one way or the other whether there's a genetic marker that plays a role in Mr. Henry's case, right? Answer, that is correct. And again, they rely on this genetic marker as the so-called accelerator to get the cirrhosis developed quicker than 10 years. So their expert admits he can't say one way or the other, admits it. And again, like I've said already, there's no genetic testing. There's no proof that he has a genetic marker. This is just sheer speculation. So it's really two-founded speculation. They're speculating that he drank prior to being 14, and they're speculating that he had some genetic marker. And so since they've conceded the science, Your Honor, there's no way that this alternative causation theory should come in.
All right. And I think it's important to point out for the record that really and truly, under the Williams case, what we're referring to here would be an independent alternative causation theory that has to be applied to a reasonable degree of medical probability. Just as important too, we can't overlook, Williams is not the end of the discussion. You also have Hallmark, and it appears to me that what we're really referring to is whether or not these opinions meet the assistance requirement under Hallmark. Because remember, under Hallmark, we had three requirements. We had qualifications, we had the assistance requirement, and limited in scope. And so when we go to the assistance requirement, really and truly, you're going beyond the opinion being proffered. You have to make a determination as to whether or not the opinion is generally accepted in the scientific community, has been tested, peer reviewed, and all those wonderful things. I don't have the case right in front of me. I'm just going for rote memory. But that's truly important because it goes down to the foundation. Just as important, too, I'm going to go back to Hallmark again. And remember, in Hallmark, our Supreme Court rejected Daubert, right? They did reject it. But what did they say? When they made reference to Daubert, they said, look, trial judge, you're the gatekeeper. Right? Isn't that what they said? That's my recollection, what our Supreme Court said. And that's really important because there was a time here in the 8th Judicial District Court where judges would say, just let it all in and let the jury decide. But I think we've become a little more sophisticated than that. And at the end of the day, we have to make a determination as to whether any expert opinion is just not that expert's opinion, but whether it's meets the assistance requirement and all the factors that are set forth therein. And so when I look at this, and there's really two issues. As it relates to the genetic marker issue, there has to be something more than a maybe, or it could be. There has to be a foundation for that. No, there's been no foundation laid in this case that this particular plaintiff, Mr. Henry, was predisposed based upon genetic markers, right? There's nothing there. Interestingly, even if that was there, then I could see a potential issue of whether or not they'd be on the hook anyway, if you understand, but there's no evidence for that. And then when it comes to drinking, I think in order to opine that drinking was the independent alternative cause in this case, there would have to be a foundation based upon the medical literature that Mr. Henry was drinking anywhere from 10 to 15 years. We just have that's what the state of the evidence would be. And then if that foundation was met, then potentially you can offer up an independent alternative causation theory, because the 10 to 15 year time period would be supported by the medical literature, right? And I think it's important to really point out that, you know, and I think this happens sometimes, just because something's published doesn't mean it's generally accepted in the medical community. That is peer review. And that's a rigorous process, as we all know. It just is. And then I think this gets lost in the discussion too. Peer reviewed for what purpose? Right? We see that sometimes when we deal with the biomechanical stuff, but this isn't that case. But anyway, I'm looking at it from this perspective, and I do understand what my charge is. My charge under Hallmark is to be the gatekeeper. We accepted that portion of Dalbert. And when I look at it as it relates to the genetic markers, there's no foundation for that. When it comes to the generally accepted drinking time period, which potentially could result in cirrhosis of the liver, is 10 to 15 years. There's no evidence in this case that Mr. Henry started drinking alcohol at a high rate from the age of, I guess it would be 9 to 14.
14, yeah, 9 to 14.
Or 9 to 14, right? But he started drinking then. There's no foundation for it. There just isn't. And I'm going to grant the motion for all those reasons.
I think this also makes motion to eliminate number 7 move.
Hang on 2 seconds. I will double check. I have them in a different order. Yeah, I think you're right. I think that does make docket 518 number 7. Although, you know, I think for the record, perhaps what we should say, we should just have that one granted when you get there for the same reasons rather than moot, unless you want to withdraw it. Up to you.
Yeah, we'll just grant it now rather than.
What is number 7?
That's the motion to preclude Tanner and Dr. Robin on the same basic argument.
Well, I think the question is whether or not he is still a good steward of his liver. And so I thought 7 was broader to exclude all references to alcohol. I'd have to look at 7 is what I'm saying.
Let's just keep moving. That's fine, we'll just keep moving.
We'll look at it when we get there.
Okay.
I'll make a note.
I thought 6.
I thought that one was a broader motion.
I thought 6 was.
What is next?
So we believe 3, 4, 5, and 6, either non-ops or 3, 4, and 5, and then number 6, I think may have been withdrawn, or was withdrawn.
We agree.
Okay, Mr. Parker, can you
Look at the docket numbers. I have those.
clarify
I don't
that
have
for
the
my
document.
court clerk so she'll have an easier time with this?
Your Honor, motion to eliminate number 3 is docket 500. That's to pre-admit the concentrate testing. There's no opposition to that.
Granted.
Next one is docket 501. This motion to eliminate number 4 to pre-admit the Loma Linda article and the American Journal of Gastroenterology. We didn't oppose that. I think in one of those articles, there's a reference to real water being out of business, and Brianna and I have agreed to a redaction.
That's fine.
Granted with that redaction.
And then docket 502 is plaintiff's motion to eliminate number 5 to pre-admit the Eurofins testing. There was no opposition to that.
Granted.
And I think number 6 was withdrawn, John, but I don't know the docket number.
Yeah, that was the pre-admit the commercial and business plan, and I don't have the docket number on that.
I don't have it on calendar, so.
It's not on calendar, I guess. If we do see 6, remember that's withdrawn.
Oh, we withdrew that.
Yeah,
I think it was withdrawn.
It was withdrawn.
That was withdrawn.
So I'm not seeing it, so
Okay.
I can check it.
So the next one we would show is docket 503. And I think this will be a quick one. This is the Dr. Goldsmith one. Mr. Kaufmann will be
Okay.
presenting the office.
Number 7 is that.
I have 7 later on the court's calendar. I don't know what. I put them in the order they were on the court's calendar, and
It is later on the court's calendar.
that's where I have it, you guys.
What do you have next, 8?
Yeah, I show plaintiff's motion limited 8 is the next on the court's calendar, which is docket 503. And that's the Goldsmith one.
Yes, Your Honor, I agree. This one should be fairly quick. in Gallagher, this motion, the same exact motion was granted as to pre-admitting Dr. Goldsmith's testimony and opinions, but no waiver of any objections to the page and lines that are designated. So I think if we are consistent with that prior order, the motion is granted. We'll submit the page and lines to Real Water and they'll be free to raise any objections to those page and lines.
All right, Mr. Kaufman, it'll be up to you now.
Okay, I'm sorry, I wasn't sure if Eric was done. I didn't want to speak over him. Your Honor, very briefly, this is not the same as it was in Gallagher. In Gallagher, the Real Water defendants named Dr. Goldsmith as an expert. We have not done so in this case. So at this point, the only party left that has named Dr. Goldsmith is the plaintiffs. And they're essentially seeking to pre-admit their own expert testimony. Additionally, just for the record, I think that presenting Dr. Goldsmith as Real Water's expert at this point is factually incorrect. And then finally, given the court's ruling on the prior motion and motion for summary judgment, I don't really think the epidemiological evidence is at issue anymore. And I'm not even sure Dr. Goldsmith's testimony is relevant to any of the remaining issues, which are medical causation and punitives, because his testimony doesn't go to notice and he has no medical causation opinions for these plaintiffs. And I know that for a fact because I know he's never seen the medical records. At least I've never sent the medical records for any of these plaintiffs. So with that, that's all I have to say today, Your Honor. Thank you.
Thank you, sir.
Your Honor, these cases have been coordinated for discovery purposes. The Dr. Goldsmith was retained by Real Water. His opinions were disclosed by Real Water. At the time he was deposed, he testified on behalf of Real Water. Those are the opinions and testimony that plaintiffs seek to pre-admit. Those were the opinions and testimony that were pre-admitted in the Gallagher trial. So it is the same motion for all intents and purposes. If Real Water wants to argue that Goldsmith's same opinions and testimony are somehow less credible today because Real Water no longer likes them, it's free to do so, but that does not affect the admissibility of his opinions and testimony. It doesn't change the court's order and ruling in Real Water, and the argument does not affect the admissibility or any of the issues that are raised in the motion of why Dr. Goldsmith's opinions and testimony are relevant and admissible in this case. So because they've made no argument challenging the admissibility of Dr. Goldsmith's opinions or testimony, we ask that the court do exactly what it did in the Gallagher case where Real Water opposed this same motion and generally grant the motion that his opinions and testimony are generally admissible without waiver of any specific objections that Real Water may have to the testimony that's designated.
And I'm going to rule in line with my prior decision in this matter. And I think the prior decision was what, motion in limine number 37. This is motion in limine number 8. Is that correct? Yeah, I'm going to go ahead.
That is correct, Chair.
Yeah, I'm going to go ahead and grant it. And for a lot of reasons, not just based upon the prior record, but in cases like this, epidemiology opinions are important. They are, that's part of the burden. I'm going to go ahead and grant it. What's next?
We believe MIL number 9. I'm hearing
Yeah,
Ms.
docket
Switzler
504.
whispering.
Okay. And that's and which one is that again, Mr. Parker?
Admit the life tables is not.
Oh, I'm sorry.
It's docket number 504.
Plaintiff's motion limiting number 9 to pre-admit standard life expectancy table.
Yes, Your Honor, thank you. These are the standard morbidity and mortality tables published by the Department of Health and Human Services and contain statistical data regarding average life expectancies compiled by the CDC. There's an argument that these tables somehow lack foundation. They're presumed authentic under NRS 52.135. They're government publications. They're not inadmissible under the hearsay rule. They're data compilations under NRS 51.155, the public records exception, and then NRS 51.165, required reports exception. The foundation argument is this backwards argument that we somehow have to prove that Mr. Henry would live as long as the statistical average in the data reflected by the CDC. That is backwards because the life tables are evidence of a person's life expectancy, not vice versa. They are relevant in this case with respect to Mr. Henry for two reasons. Number one, he had a liver transplant. He's going to have future medical issues that last the entire lifespan that he has left. So his life expectancy is a relevant issue, regardless of the second issue, which is the loss of life expectancy that he's incurred as a result of his liver transplant. So for both of those reasons, the life tables are relevant to Mr. Henry. There's no dispute as to the future medical care that is going to last the life expectancy. Finally, Your Honor, the life tables are just one piece of evidence that can be considered with respect to plaintiff's life expectancy. It's not conclusive proof. There's a jury instruction that speaks to this exactly. It's the statistical facts related to the average life expectancy of individuals based on the data collected by the CDC. It's not controversial. We cited the case law supporting that these tables are routinely admitted. They were admitted in Gallagher with respect to Kathy Ryerson because they were relevant to the death case there and the heirs claims. And consistent with your prior order in Gallagher, we asked that you would pre-admit them for Mr. Henry in this case.
Yes, sir.
Joel Odou on behalf of the Real Water defendants, very briefly. It is a foundational issue. It is a gatekeeping issue. In this particular instance, plaintiffs do not have an expert that's going to opine that Mr. Henry's life expectancy is consistent with the life expectancy tables prior to his liver transplant. That's because Mr. Henry has an alcohol abuse problem. They want to turn evidence on its head and have the jury presume that he would have lived this long but for Real Water. That is incorrect. He would not have lived this long, even excluding Real Water, because of his alcoholism and his other lifestyle choices. What the plaintiffs are asking you to do is to pre-admit this and place the burden on Real Water to prove the negative. And plaintiffs have the burden. It's plaintiff's burden to show that Mr. Henry's life would have been as within this life expectancy table. These foundational issues are critical in this case. These are very important issues. The court should act as a gatekeeper and require the plaintiffs to lay a foundation, and Mr. Henry would meet these life expectancy tables, but for his consumption of Real Water. They haven't done that. And for that reason, pre-admission should be denied in this case. This case is vastly different than the court heard with Ms. Ryerson. And for those reasons, we don't think pre-admission is proper.
Okay, thank you, sir. Mr. Pepperman.
Your Honor, there are public records that are one piece of evidence of a person's life expectancy. They're free to argue that Mr. Henry wouldn't live as long as the average person, or the statistical life expectancy is based on these published government reports and data compilations. They're not being precluded from anything. But the case law is clear. We're allowed to admit self-authenticating public data as evidence of individuals' life expectancy. There's a pattern jury instruction exactly on this point. So it's relevant and it's authentic, if there's foundation, and they're not losing any arguments that they otherwise would have to dispute the evidence. So we ask it be pre-admitted.
All right. I just have a couple comments as far as this is concerned. Assuming it's a wrongful death case, say where you potentially might have a claim for loss of support, or a personal injury case involving permanent injury and some impact on lifestyle or mobility issues. There are many different things. I've never seen a case where a life expectancy table is not admitted. Right, and just as important too, it is clearly the type of record, governmental and or public record, that a trial court could take judicial notice of. And I mean, based upon that, and there can be a lot of arguments regarding the fact that Mr. Henry might have had other issues that would have impacted his life expectancy, but at the end of the day, you know, these are life expectancy tables, and when you look at life expectancy tables, there's no perfect, say if you qualified it and said, well, life expectancy table for a non-smoker, non-alcohol user, those might have a average life expectancy of 85 years or 90 years. But these are, you know, this is a big pot of everybody. And I'm going to go ahead and permit it to be pre-used, because this is something that happens in all cases where it would be appropriate. I've never seen anyone exclude a life expectancy table. So let's go to the next one.
So granted.
Granted, yeah.
That will be docket number 511, plaintiff's motion in limine number 11 to instruct the jury on standard product liability instructions.
Your Honor, we'll withdraw this motion. I think it's unnecessary.
Yeah.
Next will be docket 505, plaintiff's motion in limine number 12 to designate Blaine Jones as a managing speaking agent of Real Water.
Your Honor, this is one that was granted in Gallagher. It's the same exact motion. Blaine Jones has been designated as the managing speaking agent of Real Water in every case and every trial we've done so far. I don't think there's any reason to even spend much time arguing this motion. I think it should be granted in line with Gallagher.
Mr. Odou wants to make sure he preserves his record.
Mr. Freeman will actually be making this argument, Your Honor, but thank you.
But I understand why. You want to preserve your record, and I don't blame you.
Yeah, and we want to preserve our record, and again, I just think it's inappropriate. The test is not for determining who is a speaking agent for a company at trial. In fact, having them designate someone who was only the 30B6 representative for 2 topics, and he testified as to not being involved in other aspects of the business. He wasn't involved in customer complaints or sales, etc. But they want to have him be the designee for all issues and to take away Real Water's right to determine who speaks for it. Thank you.
Thank you, sir. Mr. Pepperman.
Your Honor, as was determined before and argued before, Blaine Jones meets the managing speaking agent test under the Palmer v. Pioneer and Associates case. But it's not just that. He also meets the definition under NRCP 32.3 because he was an officer of Real Water Inc. at the time of his deposition. And then on top of that, he was also produced as to several topics as the Real Water 30B6 designee. So for all those reasons, Blaine Jones is a managing speaking agent of Real Water. He speaks on behalf of Real Water. He's an officer of Real Water, and his deposition may be used for any purpose during the trial. So in line with what you ruled last time and what every other court has ruled, we ask this motion.
And it is important to make a reference to the Palmer case because that's controlled. There's no question about it. And ultimately someone has to speak on behalf of the organization also. I'm gonna go ahead and grant the motion in reliance upon Palmer and the points and authorities on file hearing. Let's move to the next one.
Okay, next will be docket number 506, plaintiff's motion in limine number 16 to preclude defendants from arguing or inferring that violations of law or regulations are relevant to the compensatory and punitive liability.
All right, Your Honor, court's indulgence. Your Honor, I believe that this motion was argued in Gallagher, but it wasn't ruled upon. I don't believe Real Water opposed it, but UNFI did, and it was taken under advisement, and then UNFI settled out, and so there was no ultimate ruling. But it's a fairly straightforward motion that, you know, all we're trying to do is preclude any type of argument that some compliance or lack of violations of regulations, you know, are relevant to compensatory or punitive liability in this case. The only, you know, regulation that's been, you know, touched on as potentially at issue in this motion is the fact that there's no specific regulation saying you have to test for hydrazine in water or saying hydrazine cannot be in water. But as we all, I think, understand and agree to, that the regulations don't identify every possible toxin.
I mean, ultimately, what it comes down to is whether or not the product is defective under the restatement of torts 402A. A defective product unreasonably dangerous. That's the test.
That's
right?
correct, Your Honor.
And nothing, the focus is not on government regulations, it's not on the conduct of people, it's on the product.
That is the argument that we raise in the motion.
I mean, that's the law.
That's
I
the
mean,
law
that's what
that we
I'm
cited in
saying.
the motion. And it's why we make this motion, and we ask, and to be honest, Your Honor, to be fair, they haven't really made any such arguments in any of the other trials.
Right,
So
I understand.
this hasn't been an issue, but for the purposes of the record and to make sure that nothing comes up that's contrary to the laws as we discussed in the motion, we ask that this motion be granted.
All right. Any opposition on this one?
Yes, Your Honor. Joel Odou on behalf of the Real Water defendants. First of all, the court's already found the product is defective. Does not meet the reasonable consumer expectation test. The court's already ruled on that. We're quibbling over the form of that summary judgment order, but expect to have that to the court this week. So the issue for compensatory damages is there really isn't one, because the issue is medical causation and the plaintiff's damages. But there is an issue for punitive damages. And Your Honor, the reason why the court hasn't previously ruled on this motion is this motion has changed over time. When this motion was before you in the Gallagher case, this motion was filed preemptively to prevent UNFI and other distributors who house Real Water at their facilities from arguing that some federal regulation shields them from having to test Real Water for toxins or impurities because the product was sealed when they received it. So UNFI potentially could have argued that this federal regulation shields them from negligence, and would have been right for this court to grant this motion in regards to that if liability was contested by them. You know, they're the ones who tested the water hydrazine, which is a different issue, but I think that's why that issue went away. You know, in the context of this case and this claim, unfortunately, this motion has morphed over time. We have heard arguments in other trials, not before this court, that the granting of this motion would preclude Real Water from arguing in the punitive damages phase that their water was tested pursuant to various standards. So that evidence is not going to come in because that would violate this motion in limine. Your Honor, that is not what this motion is styled as. They haven't given us notice that they're going to make those arguments. The only reason why we're aware of it, because those arguments came up in one of the prior trials, and that judge excluded them making that argument and said that Real Water was able to put its compliance with various standards on for the jury in terms of punitive damages, because it goes to the reprehensibility of the conduct. It also goes to the ultimate decision on punitive damages by the jury. And none of that has been raised here. And so we want to make sure that if the court's going to grant this motion, which it should do it on a very narrow basis as to the compensatory damages, which again, that issue's been decided. Summary judgment was granted. The jury we're not going to put on evidence that the water doesn't have hydrazine. In fact, our principal, Brent Jones, testified it shouldn't have hydrazine, and it does have hydrazine. So that issue is not going to be contested for the jury. What is going to be contested is the degree of punitive damages that a jury should award. And this is certainly something we should be able to cross-examine Dr. Hutt on in terms of the procedures that Real Water did have in place and did take that she apparently wishes don't exist because she fails to acknowledge them. So really, Your Honor, we don't want to be limited by the granting of this motion and being able to cross-examine Dr. Hutt as to the issues we anticipate will come up at trial. We also don't want the unintended consequences of having our hands tied in contesting punitive damages in this case. And that's why we've opposed this motion.
Your Honor, I'm not aware of which trial. There's no trial transcript testimony or any page and lines in the opposition discussing what Mr. Odou is referring to. But certainly in Gallagher and the other prior trials, the facts surrounding Real Water's actions with respect to testing were admitted and have not been contested by the plaintiffs. That is different. Factual information is different than making an argument that is irrelevant and misleading, that somehow there's been this compliance with testing regulations or rules that are relevant to any compensatory or punitive liability. That's what the plaintiffs seek to exclude by this motion. Like I said, they haven't made that argument, in at least not to my recollection, and I haven't seen any transcripts suggesting that they have. But for prophylactic purposes, this is a straightforward motion that precludes them from arguing that they somehow didn't violate laws and that don't exist, and can argue to the jury that that's relevant to compensatory or punitive damages, which is not supported by any case law that they've cited, which is clearly irrelevant and misleading, and doesn't preclude them from, stating facts that they did certain testing at certain times. So they're arguing something that's outside the four corners of the motion and have not made any argument which would justify denying this motion, which they previously haven't even disputed.
Anything else on that, Mr.? Because I don't remember it being developed in that regard as it pertains to hypothetically government testing to support the position that there wasn't a conscious disregard and or reprehensible conduct, something like that.
Your Honor, Joel Odou for Real Water. We did cite in the motion the punitive damages argument, so might have been mistaken in that regard. It goes to the conscious disregard. It doesn't go necessarily, and it goes to the reprehensibility. It doesn't excuse the conduct completely. It just goes to the degree of the reprehensibility. In other words, I'm trying to think of a better way to say this. Real Water
No, I understand. No, I understand the argument, but go ahead, you make your record. I understand the argument.
Real water didn't touch for hydrazine. That fact is uncontested and the fact that the water standards admitted by all the experts doesn't require testing for hydrazine does not excuse the fact that there was hydrazine in the water. And that is not an argument we're making. We're making an argument that the water testing standards don't require testing for hydrazine to go to the reprehensibility of the conduct. In other words, if there was a requirement to test for hydrazine and real water didn't do it, that is much more reprehensible than being negligent and not discovering the hydrazine in the water. Still negligence, still at
Okay,
fault.
but remember this, when we're talking about a defective product, we're focusing on the product and not necessarily the conduct. I understand what you're
Correct.
saying regarding potentially conscious disregard vis-a-vis punitive damages.
That's all we're arguing, Your Honor. The conduct is irrelevant for strict liability. The court's already found that the product's defective. So now the conduct does become relevant for the punitive damages. And the conduct is important for punitive damages, and the reprehensibility element doesn't negate the fact the product's defective. It just goes to the amount of reprehensibility of the conduct in terms of, what happened. The jury's got to know about the conduct. Otherwise, otherwise the plaintiffs would put in all the bad conduct. We can't put in any of the good conduct. That's inequitable, and that would be improper.
Mr. Pepperman.
Your Honor, we don't have to, it's written in black and white in their opposition. They argue, quote, argument or evidence that hydrazine does not appear in a list of chemicals Nevada regulates and is probative of defendant's actions and lack of malice and recklessness in testing.
Right.
That is totally irrelevant. The fact that hydrazine isn't a specific toxin that's regulated does not have anything to do with plaintiff's theory of punitive damages, which is that they should have done non-targeted GCMS testing in response to before they introduced this novelly manufactured water onto the marketplace. Before they should have figured out what's in the water before they started selling it.
Well, I mean, I didn't want to bring that up, but I thought about that as I was listening to the argument. Maybe when you have a new a new production procedure in place involving titanium rods, maybe there should be some sort of broad-based testing of the product before it's entered into the market.
Yes, that's one of the theories as to punitive damages, and is also in response to the numerous complaints that start coming in over the years about, well, gasoline-like substances in the water and fishy smell and oily substances. All those complaints that we've gone over that they received, they did no testing to determine what possibly that substance could be or what possibly is in the water. We know they had this non-targeted testing, cost a couple $100, could have done it, widely available. They didn't do it. So those are the issues and allegations. And what they want to do is come in and they want to wrap themselves up in these regulations and say, oh, we complied with the law. We didn't act with malice. We didn't act with conscious disregard. It's a totally improper argument. It's irrelevant. It's misleading. It's confusing and prejudicial. And that's why it should be excluded.
And I notice I'm looking here, and I just want to make sure, because this was one of those that there doesn't appear to be a lot of case law from either side on this specific issue. Is that true, or?
That is true, Your Honor.
Okay.
Although we did cite some case law. First of all, Your Honor, as we have now learned, the plaintiffs have strayed from the four corners of the motion, and now we've gotten to the real heart of the matter. And that's why Real Water was concerned this was a wolf in sheep's clothing. Now that we've established it's a wolf in sheep's clothing, we should wrestle with the actual issues, which were not in the moving papers. But we cited the Stackowitz case to talk about there is an ability to show some compliance in terms of the punitive damages element, and in particular, the Philip Morris case as well, that shows the jury is entitled to lawful action which do not harm. Defendant should not.
Wait, say that again. I'm on my.
So I have to sit closer to my computer. I apologize for sitting down, Your Honor.
Oh, that's okay.
So Your Honor, we cited in our brief, the Philip Morris USA versus Williams case, 549 US 346. It's on page 6, starts on page 6 of our brief. The defendants do intend to ask for Philip Morris instruction and fully inform the jury that its lawful actions do not harm the defendants, should not be considered in any punitive damages award. And that in that case, they had argued that the punitive damage award on trespass, when the plaintiff believed they have a legal right to enter on the property, was a defense. Wasn't probably a very good defense, but it was still something that the jury should hear.
Wait, Phil Morris is the tobacco case.
Correct. It was cited that Jace on page 7 of our brief, we cited the JCB Inc. versus Union Planters Bank case, which was out of the 8th Circuit and was cited in Philip Morris. So, Your Honor, the issue is the reprehensibility of Real Water's conduct and the ability of Real Water to cross-examine Dr. Hutt. Plaintiff cited the Stackowitz case and other Nevada cases regarding this consumer expectation test. Those don't address punitive damages. And that's what the court just said. There's not a lot of case law addressing punitive damages. The punitive damages issue, which was not framed in plaintiff's motion, but which we were concerned would arise, and now it has, is that plaintiffs want to argue that Real Water, you just heard, they said, well, Real Water didn't respond to any of these complaints. They didn't do testing. Well, Real Water did. It just didn't do testing that was adequate to find the hydrazine. In particular, we argued in a number of the cases in detail since Gallagher about what Real Water did to investigate customer complaints. We talked about some complaints from Chevron, some complaints from different gas stations. And so the evidence has been more developed than this court heard in Gallagher about some of these customer complaints. And I know that motion's coming up and we'll be arguing further. But the issue really is the reprehensibility of the conduct. If Real Water tested for all the things that they're required to test for, that doesn't absolve them of negligence. And that's what this motion was really aimed at. Well, the court's already found that the product is unreasonably dangerous. And now the question is the culpability of Real Water for putting that unreasonably dangerous product in the market. The jury is going to make its finding on that. Real Water is entitled to show that there wasn't a complete reckless disregard. They did the testing that was required. They just didn't do the testing that would have found hydrazine. That is a fact. That shouldn't be excluded by way of this backdoor motion in limine.
That's right, Mr. President.
Your Honor, 3 things. Number 1, he's conflating the fact with the regulation. We're not seeking to preclude him from arguing about the facts that they did testing or the facts that they didn't find hydrazine or didn't know to test for hydrazine. Those are facts. We're seeking to exclude the argument regarding compliance with regulation. Number 2, he says this punitive damages issue isn't raised in the 4 corners of the motion. That is just simply inaccurate. It's a whole section in our motion, starting on page 6, and we cite to the key case on this in Nevada, the Wyeth v. Roat case. In that case, the argument was we can't be held responsible for punitive damages because we complied with all the FDA requirements for labeling and testing regarding the drugs. So therefore, no punitive damages. And the Nevada Supreme Court said, no, that's not relevant to the question because the conduct, even though you may have technically complied or may not have violated any specific rules or regulations that were articulated, the conduct was fraught with reprehension and deception. And that was the question, the facts of what the conduct was. And so those facts are still fair game. We'll argue the facts of the lack of testing, the failure to do non-targeted GCMS testing before they introduced the product, the facts that they failed to do that before or in response to any of the customer complaints, the facts that it would have discovered the hydrazine, widely available, $200, and they could say why they didn't do that. Those are the factual disputes. We're not seeking to exclude any of those facts. But the law to argue, hey, we complied, we didn't violate any rules or regulations, that argument as stated in Wyeth v. Rowett, is irrelevant, it's prejudicial, and it's misleading as to what the factual issues are related to the actual reprehensibility and conscious disregard. Finally, the third thing is this reference to the Philip Morris case. Philip Morris had to do with a constitutional due process issue of not being awarded for punitive damages based on harm to other people who were outside the state and not plaintiffs in the particular action. That's totally irrelevant to this issue. We're not arguing that they should be held responsible for punitive damages to harm caused by anyone besides the plaintiffs in this case. So for all the reasons discussed, we'd ask, and in the motion in reply, we'd ask the motion be granted.
And for the record, I want to make sure I'm clear. Wyeth was cited on page 7 of the motion.
Yes, Your Honor, or the motion, yes.
Yeah, what I'm gonna do, just to make sure I'm clear, because I haven't read Wyeth in a long time. I'm gonna read that. Then issue a minute order.
Thank you, Your Honor. Joel Odou for Real Water. We just, when the court reads Wyeth, just note that we're not saying punitive damages are negated.
No. I understand the issue. I
We're
really
saying
do.
it goes to reprehensibility.
I
And
understand.
Wyeth, they argued you can't get punitive damages because we complied with the law. That is not our argument.
But I'm gonna read Wyeth and see what Wyeth has to say. That's what I did. So, are you all okay with it? Okay. So where do we go next? So what time is it? 10:48.
We have some numbers.
The next motion.
Okay. The next up will be docket 507, plaintiff's motion in limine number 18 to preclude reference to the fact that Blaine Jones is now a plaintiff.
Our records show non-ops to 18 to 19. I don't know if that's true.
Yeah.
So I think this should be granted, John. I don't think there's an opposition to number 18.
No opposition for 18 and 19?
18 and 19, that's what it shows on my list, that they're both not
That
ops.
is correct. There's no opposition to docket 507 and 508.
We'll grant those.
We showed them as moot.
So the next up will be docket 509, plaintiff's motion in limine number 21 to pre-admit real water customer complaints.
Your Honor, this is the one that we've discussed. Like I said, we took well over a day in the Gallagher case to discuss each and every one of these customer complaints.
And I took this under advisement, and this is the one I came up with the minute order on. Is
That's
that-
correct, Your Honor. You gave this a lot of time, more time than was given, I think, in some of the other trials to maybe 10 to 12 of the motions. This one was hotly contested, Your Honor, because we also, in addition to Real Water, we also had at that time UNFI, I'm sorry. And we also had the meter, defendants in that as well. So this one went on and on and on. But the court in painstaking, I'd say applied a painstaking approach at looking at each customer complaint one by one. Not only the complaints, but the timing of the complaint, who the complaint was made by, who the complaint may have been reviewed by, and ultimately the court granted the motion to allow the customer complaints to come in. That's what's happened. And in every case since then,
I looked at Stackowitz, Kraus, and all the Nevada authorities specifically relating to that.
you
And I don't
did,
mind saying this, Kraus was pivotal in my decision.
Your Honor, you looked at Kraus, you went over the restatement second of torts 402. I mean, you went over everything. You went over the Marsicato case, the Mapes case. You addressed every case, even the Wilson Circus case in terms of common exposure. I don't know how much we can go over it today, or is necessary to go over today, Your Honor. But I think the briefing certainly identifies everything that was discussed. Nothing has changed, in my opinion. There were 27 complaints identified in our brief. in addition to the 87, well, actually 100 plus plaintiffs, 27 lawsuits. I think the papers here discusses everything, Your Honor. Oh, I forgot, Your Honor. We also went through the Harley Davidson case, the Wet and Wild case, all allowing pre and post customer complaints or similar incidents, Your Honor. And in fact, the Kraus case talked about not even having a particular lever involved, not knowing the lever was triggered, but also the Supreme Court decided it doesn't. They've allowed in the box crushing case, Your Honor, you don't even have to be the same type of box crushing machine that was discussed in that case. So, Your Honor, I don't know what Mr. Odou or perhaps Mr. Kaufmann can say that's not already in the papers, already fully fleshed out in the briefing. But the customer complaints also are business records under NRS 51.135. I just don't see where and why these customer complaints wouldn't come in. And if Mr. Odou would like to take them one by one, then fine, I'm prepared on rebuttal to go through each one of them and say why they should come.
Thank you, Mr. Parker. Your Honor, Joel Odou on behalf of Real Water. We do think it's important to make a record if we're going to treat all of these as part of this motion. And with the court's indulgence, I'd like to point out a few things if that's fine.
Mr. Odou,
It won't be that long.
I can't remember one time I've stopped you from making.
You have never, no, Your Honor, you have not. I guess that was my way of saying I need to say a few things.
Absolutely.
That will not be long. Your Honor, this issue has been very well developed since this court's ruling in Gallagher. In fact, we appreciate this court's ruling in Gallagher because we argued extensively in the Hunwertson and the Wren case. And to give the courts a preview of where I'm going, not that this is binding on the court, I think it's just interesting. Judge Kishner made some different rulings and Judge Hardy made some different rulings. I think Judge Hardy's rulings were closer to yours. And don't get me wrong, Judge Kishner agreed with a lot of your rulings, but there were some things that were excluded. The argument that we made in front of Judge Kishner and Judge Hardy that was not accepted, which I still think it's a good argument, and Real Water thinks it's a good argument, and so I want to make it here, is all of the cases cited, whether it's the Genis case with the revolving door injuries, it's the Wet and Wild case about the injuries at the water park, the Harley Davidson case, which is about a motorcycle, all of those cases noted that the relevancy of the other accidents is dependent on the purpose that it's being offered for. And here, the purpose is punitive damages, and that kind of makes it a lot different. Liability is resolved in this case. The issue here is punitive damages and the reprehensibility of the conduct. And in all of those prior cases where they were arguing over liability, the mechanism causing the injury was visible. It was something that was perceivable, something that in a reasonable degree, excuse me, let me start over. In a reasonable and prudent person, or negligence test, a reasonable and prudent person could perceive the danger, could understand the defect, could understand there's a problem. That is not the case here. These are liver injuries. These are internal injuries. They're not visible. And that's what distinguishes our case from all of the cases cited and the purpose for which these complaints are being offered for. These other instances include quite a bit. They include like Mr. Watkins' complaint. Now, in this case, finally, we will have an opportunity. Well, I shouldn't say that. In this case, Mr. Watkins will testify for the fourth time, I believe. And we'll have an opportunity to cross-examine him, so I misspoke. His doctors didn't want him to drink alkaline water, so he didn't. He has now changed that to be his doctors told him not to drink real water, and therefore real water was on notice, that there was a problem, they should have done testing on and on and on. That goes to the weight, but it also goes to the admissibility of some of these complaints that points out the problem. We have the Williams test for medical evidence as to when medical evidence can come in, it has to be to a reasonable degree of medical probability. That's not the standard for complaints. We understand that and looking at all the cases cited by the court. But again, in all those cases, the danger was perceptible to a reasonable and prudent person. Here, we have multiple complaints that have nothing to do with hydrazine. In fact, no expert will ever testify that any of these complaints had anything to do with hydrazine. They'll just speculate. And that's where we start to get into a problem. Speculative testimonies, especially as to punitive damages that has this heightened standard, is really unfair and it's really prejudicial. And looking at these complaints, we could take them one by one, but I'm sure that the court will hear them at trial. I'm sure that we will make our objection at trial. We're making our objection now just for the record. The plaintiffs are going to ask Lois Kessler to speculate as to what caused her fatty liver. She's going to jump to the conclusion it was caused by real water. Therefore, they're going to argue real water's reprehensible conduct for not investigating her fatty liver. That's a medical diagnosis. A lay person is not going to know to go do targeted GCMI testing because of these types of complaints. And that's the argument that's going to be in this case. Trey Fisher, who got water poisoning from ingesting 1.5 gallons of water in a 6-hour period. Plaintiff's expert concedes that that was likely, or that could have been the cause of his complaints. But again, they want real water to jump to the conclusion, oh, no, it was hydrazine in the water. They should have known. We have, I don't know if the plaintiffs are going to offer testimony of other plaintiffs, of Mr. Belsky or Mr. Haley. We've objected to those. Those people have already had their day in court, and to award additional punitive damages based on those complaints would be an error. It would just be piling on top of it. We have Mr. Dosatel, who would like to offer testimony as to his daughter. We've not seen the daughter's medical records. He wouldn't even tell me his daughter's name in his deposition. Yet somehow, even though he never complained to Real Water that his daughter got sick, that's supposed to put Real Water on notice. That doesn't fly. I believe Judge Kishner excluded the daughter's claim. We have Tom Pham. Tom Pham testified that his neighbors were given Real Water and then he saw a hospital coming. Again, somehow we're supposed to jump to the conclusion that Real Water caused the neighbors to go to the hospital. Again, there's no notice to Real Water. That's a complaint that shouldn't come in. No proof, no medical records, no expert reports, etc. Plaintiffs haven't laid a foundation. They may in this case, but they haven't yet, that these complaints show hydrazine in the water. Certainly, they haven't put it in their expert reports. They can argue that, some of these things like a strong chemical smell, a red cloudy substance, they could certainly speculate that those things are hydrazine. And we know looking in hindsight, they can offer that speculation. But to say that those things put Real Water on notice in 2014, 15, 16, 17, it's just speculation and it really becomes prejudicial. And again, even the cases acknowledged by this court talk about the purpose for which these are being offered. And the purpose here is punitive damages. Punitive damages is a heightened standard. We would request that this court exercise its option as a gatekeeper and exclude these. Certainly, as they come up, we will make objections during trial. But we think to admit them now or pre-admit them now is inappropriate. And, Your Honor, I appreciate the time. We've laid this all out in our brief. But again, the issue, it's kind of a fun little legal issue. The legal issue is all of these other cases, the harm is appreciable. You can look at a revolving door, you can look at the defect in the ladder and go, yeah, that's a similar thing. You can't do that with the liver injuries. And for that reason, we think to pre-admit all these is improper. And that's why we proposed it. Thank you, Your Honor.
What do you do? I mean, every case is unique, whether it's Harley Davidson or the ladder. But in this case, when did we go to trial in this case? How long?
October of last year, Your Honor.
So it's been a year. All right. But I remember some of the complaints like smell the water, taste, slime, red, whatever it was, and so on and so on. And here's my point. This is a little different in that you're selling a product that allegedly is fit for human consumption. That's a
If-
that's a pretty big deal,
I
right?
would agree with the court if nothing was done. But each of the complaints the court just identified were investigated. Now, the plaintiffs will say, well, they should have run them through a mass spectrometry and done all these things. That may be their argument, but when you go to a gas station and they say, hey, we had water that had an oily-like substance, and Real Water sent an employee there, bought some water, and it was fine. And the water that was contaminated, Real Water never received. They asked for it. They sent people return envelopes to get it. Again, that all goes to the weight of the testimony, but to say that nothing was done and therefore it's admissible is untrue. If the court's saying, okay, the investigation was done, it was unreasonable, that's different. And we're not saying that they are prohibited from arguing that. We're saying they've got to lay a foundation. That's going to be their argument.
Well, one of the things that were done, it's my recollection, Mr. Odou, based upon the prior trial, was to send the complainants another case of Real Water.
Yes, Your Honor, that's commonly done.
I mean, that's my recollection.
Had a product that didn't meet their expectations, replacing the product is not sinister.
It's been over a year. I remember these things.
And the court's absolutely right. There's nothing sinister about replacing a product that didn't meet somebody's expectations after you've looked and not figured out the problem. Now, hindsight says, oh, well, they should have known. Well, hindsight's 2020. What would the reasonable person do? Well, they sent the water out. It was being tested weekly, quarterly, annually, every 4 years. They were testing it. Were they testing it for hydrazine? No, they were not.
I understand, sir. Thank you. Mr. Parker.
I was glad that Mr. Odou actually came to the podium. You know, I wanted to come, but I said, you know, no one else has used the podium. And when he did it, I was like, okay, now I can do it. I felt better about him jumping to the podium. Now, I was a little surprised, Your Honor, that Mr. Odou would argue so many negligence theories in a strict products liability case. And he keeps referring back to what a reasonable person would do. That's not what the test is, Your Honor, and you know that's not the test. So I appreciate what I would consider to be novel arguments put forth in a strict products liability case, but those novel negligence arguments really are not appropriate here. Just to give some context to the conversation, Your Honor, I'm going to have Mr. Godfrey put on the screen this list of complaints. And this is, I think, on page 4 of our motion, Your Honor. And
well, and I just want to circle back. And this is why I potentially think that this is much different than even some of the other cases, in that we're talking about a product that was designed, distributed, and sold for human consumption.
that's right.
That's a different animal, right? I mean,
That's
versus
exactly right.
a ladder without a lever. You know that each time you produce one of the, I forget the sizes, but once you produce whatever size, a liter or whatever it's going to do,
5-gallon jugs.
5-gallon jug is going to be for human consumption, right?
Right.
And I get that, and so we have a lot of complaints that basically go to the issue of products sold for human consumption and oily substance in the water. I do remember that. Strong chemical smell. I remember that too. Gasoline-like substance in the water. That's upset stomach and headache. And that, to me, it appears that goes directly to the manufacturing processes.
Bingo. And I appreciate, Your Honor, first, now remembering some of these things. That's why I wanted to put it up on the screen, because you went through each one of these. And Your Honor, if you look at the dates, we know from John Marlowe's testimony.
I don't mind telling you why. I mean, sometimes I have fun with these cases. I do. I enjoy what I do. And I wanted to prepare a test that maybe the Supreme Court would adopt, because there was no test out there. And that's why we spent our time and we dug down deep, and we did a deep dive, and I came up with that 6-point test.
Well, I tell you, given the transcript that was created from those hearings, I would not be surprised if the Supreme Court, looking at it based upon this appeal that we know it's in process, may adopt something like this. Because certainly I don't believe, at least in the cases I've worked on, I've never seen the court go that deep in evaluating each potential complaint in the context of this type of case. And keep in mind, Your Honor, not only was this water, sold for for consumption, human consumption, but it was touted to be healthy. This alkaline type water is supposed to be healthier than a non-alkaline water. So looking at the list of complaints that we have here, Your Honor, going back to 2009, when Mr. Marlowe was getting sick while he was using these Russian titanium tubes to create this alkaline water, all the way into 2020, and to do the same thing. And this is what I find to be so strange. I struggle with this argument every time I hear it from a defense attorney. We tested. Well, what you did was you continued doing the same thing that you were doing before and after receiving these complaints. You never did anything different to determine what was going on. And you allowed these tests that had nothing to do with finding the real culprit as some form of badge of honor that shouldn't be used. It shouldn't be a defense because you never did anything to figure out why these people were getting sick. You just repeated the same failed tests and believing that those tests were adequate. And instead of getting to the heart of the matter, which was a poison, a toxin in this water, you just gave, in response to these complaints, more poison. And that's what happened. And when Mr. Odou gets up and says, we were trying to figure this out, well, no, you weren't. You were giving free water and you told your quality control director, Mr. Desitel, Jeffrey Desitel, you did not tell him, sorry. You did not tell him about all of these complaints because he testified during his deposition that if he knew about these complaints, he would have shut down the line, perhaps preventing many of these plaintiffs from getting sick and going into the hospitals. So, Your Honor, that's where we are in this case generally. Now, we also had Dr. Najam, and Dr. Najam testified that hydrazine in sufficient quantities can create this chemical smell, this fishy smell, this gasoline-like substance or smell in the water. And we know that this toxin, hydrazine, causes these types of symptomology and ultimately acute liver failure. And that's what this case is about. So when we went through this the first time, again, we talked about the cases we've already discussed, but we also talked about the Robinson case, which is the box crusher case I mentioned earlier. We talked about the Beatty Thomas case and how it was the Supreme Court determined that subsequent similar mishaps were admissible to show faulty design or manufacturing or elements of strict liability. We talked about the Wet n Wild case. And, Your Honor, in addition to several of these being complaints sent to Real Water in the form of Real Water business records, we also had the depositions of Tom Pham, Jeffrey Desitel, Robert Fisher, and Susan Doran, and Kessler, I'm sorry, Emmett and Kessler, discussing these complaints. And Mr. Desitel, by the way, during his deposition, went down this whole list of complaints. So, Your Honor, for purposes of these documents being pre-admitted, we have deposition testimony from the quality control person from Real Water. We know there's these are business records under NRS 51.135. We talked about the Krause Little case, which is a 2001 Nevada case. And in terms of Jerry Watkins was the wife of Steve Watkins, and she told him in 2018, if you put that list back up for me, Shane? May 26, 2018, he was in the hospital after having consumed Real Water, Your Honor. And she reported to Real Water in written form of his hospitalization, Your Honor. And if they'd done something in 2018, we probably could have avoided the 5 children who were sent from Las Vegas to Utah Children's Primary Hospital with acute liver failure, Your Honor. And then finally, Your Honor, Blaine Jones, vice president of Real Water, got sick in 2020. And he never, despite getting sick and being in the hospital, refused to shut down the line, refused to do a recall. These are just some of the complaints that we're aware of. We're also aware of complaints based upon the FDA investigations, Your Honor. But we believe that all of these complaints should be pre-admitted. Your Honor, for the same reasons you did in the Gallagher trial. Your Honor. Thank you.
Right. Regarding plaintiff's motion in limine number 21 to pre-admit real water customer complaints, I'm going to grant that. Just as important too, I'm going to incorporate by reference to my prior minute order in the Gallagher case and the 6 factors that I think are consistent with Nevada law, including Kraus and a lot of the other cases that have been referenced in the points and authorities.
Thank you.
Next up will be docket number 516, plaintiff's motion in limine number 24 to preclude Rev Chuck from offering opinion that purported lack of ozonization at Henderson plant would degrade hydrazine in water based upon his admission that he does not know the amount or degree.
That's good, if you don't wanna finish the title.
Okay.
And then the next one, I believe, is motion limiting 25.
We agree.
Are we skipping? Docket 516.
We think 516 is moot. That was a expert from ETT.
Okay.
And that would be motion in limine number 24.
That's correct.
Yes. That was Rev Chuck.
Okay.
Okay, next would be docket 512, plaintiff's motion in limine number 25.
I have no choice to come to the podium. I don't have a mic on my side, so won't be as fancy as Teddy. Your Honor, by this motion, plaintiff seeks to exclude 2 pieces or 2 different references that stem from the medical records. 1, a prior altercation, and 2, a positive cocaine test, and any argument related thereto. Neither is relevant or probative to the issues in this case. The issues in this case are Mr. Henry's consumption of real water, his liver failure, and the resulting liver transplant. In their opposition, they failed to meet their burden in demonstrating in any capacity why this information would be relevant to the facts at hand. Especially related to the cocaine references, the real water defendants even admit that they cannot establish that cocaine caused his liver injury, and they would only seek to introduce this information for veracity. However, Mr. Henry has been consistent in his testimony related to cocaine, and vague references under Nevada case law of a single drug test that happened years before his injury is not relevant and not probative to test his veracity. And we cited to those cases in our moving papers. Even if there is some shred of relevance that the defendants have failed to produce at this point, these references are substantially more prejudicial and should be precluded for those reasons.
Your Honor, Matthew Kaufmann for Real Water Defendants. Very briefly, here's where I fall on this motion. 1, as far as the pistol whip, I don't think there's any disagreement that him getting pistol whipped did not cause his liver failure. What I don't want, I'm willing to redact that record to remove references of the pistol whip, but I think there's other portions of that record that go to his drinking history and his lifestyle and his future expected life expectancy. Plaintiff's right in one respect that we're not seeking to introduce the fact that he was pistol whipped or that he tested positive for cocaine as to causation. But they do go to his character. They do go to his veracity because he denied doing cocaine in the hospital and then was found to have cocaine in his bloodstream. Likewise, and that's the point here, Your Honor. And then he's at his deposition, he just said, well, it was laced. Well, that's really a jury question, in my opinion. That's not a settled fact. Whether a jury wants to believe him or not, that's up to him. So that's where I really fall down on this motion. I don't think they go to causation, but they do go to Mr. Henry's veracity as a witness, and that is something that is at issue in this case. And like I said, with the pistol whip, I'm not too concerned about that, but there's other portions of that record. So I think that it would be wrong to exclude that entire visit, but I'd be willing to redact references to the assault. Thank you.
Your Honor, just very briefly, they still have failed to show how this is relevant in any capacity. As we cite in our reply on page 4, Barrett versus State, determining mere contradictions of a witness version of facts do not constitute an attack on truthfulness that justifies the admission of evidence. There's also another case that we cited from Hawaii that says a witness may not be questioned as to his involvement with drugs solely to show that he's unreliable or lacks veracity. Similarly, in Nevada as well, this evidence has clearly been demonstrated to be completely irrelevant, not probative, as we cite the LVMPD case as well as the Holder case that shows.
I was waiting
But
for
there's
someone
no-
to say Holder versus Aetna.
There we go, I got it in now.
I mean, it was a lawyer, that's my recollection, up north in Reno. And she was abusing prescription drug medication and opioids, right? And it's my recollection, Justice Maupin actually authored that opinion. And at the end of the day, he said, look, whatever probative value it might have, it would be unduly prejudicial, and excluded it.
Yeah, I have sleeping pills here, so very.
Isn't that what he did though? Isn't that what he-
Correct.
Yes.
And that's exactly why we make this motion and we made this argument, is because as they even admitted, there's no causal connection, and therefore there's no relevant or probative information as to these two things. And Mr. Henry himself, we cited this in our brief too. He's like, the cocaine, I've never used cocaine in my life. Wow, how did that get there? So that's why we say his testimony has been consistent. It's not relevant. It's not probative. It should be excluded for all the reasons that we stated here. And thank you.
And I think it's important to point out Holder, because factually, it's my recollection, the lawyer involved in that case from up north was actually, I guess, doctor shopping for opioids. That's essentially what was going on. And at first blush, you would think, well, maybe that should come in. And remember, it dealt specifically with some of her claims for pain and suffering, right? And Maupin said no. And that's the law, right? What I'm going to do, let me go back, and this is motion. Which one is it again?
25, Your Honor.
Yeah, docket number 512.
I'm going to grant the motion number 25, and based upon, I mean, Holder's really important as far as unduly prejudicial, because I think that was the ultimate conclusion. But just as important too, you do have to have a foundation if it's going to be an independent alternative causation. And there's not, Let's move on to the next one.
The next one I have, Your Honor, is document 510, which is plaintiff motion limiting number 27.
That's correct.
Yes, ma'am.
So Your Honor, this one is also really similar. We've had types of this and iterations of this in the previous cases. By this motion, plaintiffs want to request to exclude any evidence or argument as to plaintiff's marijuana consumption as being irrelevant, not probative, and prejudicial. In our moving papers, we argued that there's no medical expert that could connect marijuana consumption to any of the plaintiff's injuries. In their opposition, the Real Water defendants tried to point to their neuropsychological expert to somehow provide this foundation. However, even the article that she cited to support her kind of vague reference connection to marijuana, it says the associations between cannabis use and cognitive functioning are small and may be of questionable clinical importance. As this court has cited even today several times under Hallmark and Williams and its progeny, it requires more than just mere speculation to support an expert's opinions. Here, Real Water has failed to demonstrate as such, as even the article cited says it's small and not clinically important. So there's no expert foundation or testimony that really makes this evidence relevant. So it's clear that it's irrelevant. Marijuana consumption is not relevant. It's also more prejudicial than probative. There's no basis for this information, and it's would just be used to cast plaintiffs in a negative light or interject collateral issues and waste time. So we believe that this information should be precluded.
Thank you, ma'am.
Your Honor, Matthew Kaufman for the Real Water Defendants.
Yes.
I believe that's incorrect. Put it plainly, plaintiffs are claiming that their clients develop neurocognitive issues. Our expert cited to 2 papers and her own experience that marijuana can affect results of neurocognitive testing. That was not taken into account by their expert. I think they put this at issue. Also, in the past real water cases, we have been willing to agree to this motion as it applied to plaintiffs who had moderate consumption or occasional consumption. In this case, at least, we have Henry and Mr. Munoz who have multiple references to chronic daily marijuana use. That is what we're talking about here, and that's why this is relevant. Once again, it doesn't go to causation, but the fact that it doesn't go to causation doesn't mean it's irrelevant for all other purposes. So
What other purposes would it be relevant for?
well, they're claiming neurocognitive defects, and marijuana can affect that testing. So at this point, you could be said that it's arguable that some of the defects sought are actually related to marijuana use. And I don't believe that plaintiffs citing a single line from a paper is necessarily dispositive on the issue. I mean, they're free to cross-examine our expert if they want.
Is there something I'm missing as far as the expert? What does he say? So the expert report, the defense expert report, was that Exhibit B or?
I believe so. Let me pull up. Sorry, I'm working off my notes and not the actual motions. Give me a moment, Your Honor.
They, if you look on in their opposition, Your Honor.
Yeah, it wasn't very
Sorry,
long.
Matt, we can't see you, so I'm not trying to cut you off.
Well, you're fine. Please, I'm waiting for my computer to catch up, Brianna, if you got it handy.
It's their opposition.
And this is from Dr. Bailey's report?
Correct.
Okay.
So Exhibit B is one of the articles that Dr. Bailey cited to, and so is Exhibit A.
It's page 5 on their brief too, has the little snippet of the
Yeah,
opinion.
I'm reading that. I'm just trying to figure out how it's relevant.
Plaintiffs would agree, Your Honor. I want to give Matt time to respond.
And what happens sometimes, and we see this, and I've seen this for years, the confusion of risk factors to medical causation. Completely different animal. In fact, I think we saw risk factors quite a bit in the hepatitis C case. How many years ago was that, Mr. Kemp?
13, I think, Your Honor.
Okay. Shows I have a pretty good memory.
And yeah, plaintiffs would argue that there's no opinion to a reasonable degree of medical probability as to any of these. As we stated, the article cited show little foundation, if anything. There's no opinions as to the impact of marijuana consumption, the dosing requiring, to the extent it would have changed any results or anything like this. It's just completely irrelevant. There's no expert opinion cited, and so it has no point and purpose in this trial.
Your
So-
Honor.
What's your response to that?
Well, I mean, If you look at Exhibit A of our, of course, now I went too small. On Exhibit A, the Association of Cannabis with Functioning of Adolescents and Young Adults. On the first page of that, if you go down to key points, and it says findings. The systematic review and meta-analysis of 69 cross-sectional studies, blah, 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 showed a small but significant overall effect size for reduction of cognitive functioning in adults and young adults who reported frequent cannabis use. This is exactly what we're talking about. And then it goes on to say, studies require abstinence from cannabis for 72 hours in order to ensure that the neurocognitive results are not being affected by cannabis use. That's the point here. These plaintiffs are claiming they have deficits. I don't think we can say to a reasonable degree of medical certainty that these deficits are related to hydrazine as opposed to cannabis use based on the evidence we have. And I believe that's why they're relevant, because they may not have neurocognitive deficits to the extent they are claiming.
And if you look at the conclusion on that same page, that's where it says association between cannabis use and cognitive functioning are small and maybe of questionable clinical importance for most individuals.
But it also goes on to suggest that the deficits are diminished with abstinence. And that's more the point, is Dr. Sands didn't take this into account.
But don't we have to have
It's a
more?
hallmark
Don't we
problem
have to have
here.
more, right? I mean, ultimately, I'll frame it for you. Does this meet the assistance requirement under Hallmark?
Plaintiffs would argue no. That's why there's no foundation to support the opinions. There's no assistance requirement met because there's nothing supportive here to base any of the opinions on. It's just mere speculation.
I disagree. I mean, we produce papers. I mean, in one motion in limine, we don't produce papers, so we
Sir, I
lose
have
on
to
that
bet you-
count because we don't have medical literature. But now we produce medical literature, and we're still.
Sir. It's more complex than producing medical literature. Has it been tested, peer reviewed, and all those things? But at the end of the day, when it comes to some sort of evaluation, I would think it would have to be particular to this individual. And what I mean by that is this: his specific consumption, how much, THC levels, so on and so on, and for what period of time. And then I'd have to have, I would hope, some peer-reviewed article that would say, look, the consumption of cannabis at this THC level for a certain period of time can result in cognitive or and what's the term of art used here? Neurocognitive, I guess, disorder or whatever it would be. Deficits. Thank you. You're welcome.
And on top of that, it's unduly prejudicial and under the same reasons we kind of just discussed as the cocaine use as well.
Nice.
Under those case laws.
I just want to make sure I'm not missing anything.
Not from plaintiff's perspective.
I have nothing left, Your Honor.
Okay, I just want to make sure, sir. I want to make sure you had it.
I will say one thing, Your Honor. All the case law about marijuana being prejudicial predates legalization, and I don't really think that's a well-taken argument these days. That's just my personal position. Do with it what you will.
Sir, I respect that comment. I do. You know, there's no question society does change. You know, it does. But here's the problem with that, and I don't mind saying it, you know, we're not for sure that everyone on the jury might have that same viewpoint, sir. I think you have a more forward-thinking evaluation of the evidence, and I won't disagree with you. I won't. But what I'm going to do is I'm going to grant the motion for the reasons that forth there.
Thank you, Your Honor.
So we're doing pretty good.
Yeah.
We're break.
Yes.
Yeah, we're going to take a quick break.
So you're 10 minutes, 15,
10 minutes.